Hi, this is our video presentation titled Reforming Regulation and Policies in Malaysia's Healthcare System, Alternative Dispute Resolution, and Medical Research and Patient Safety. These are our team members: Dr. Nur Najmi, anesthesiologist from Perlis; Dr. Amira Aisyah, anesthesiologist from Perlis; Dr. Josephine Tang, family medicine specialist from Klinik Kesihatan Bandar Tasik Mutiara, Penang. These are the contents of our presentation for today. Malaysia strives to achieve universal healthcare coverage. While significant progress has been made, there remain challenges that impede the full realization of UHC. One of the issues is regulation and policies governing the healthcare system in Malaysia. We had identified two areas that we feel is important and has room to improve in terms of policy and regulation, and they are applicable in our daily work. Thus, we will discuss on alternative dispute resolution in healthcare and the regulation of medical research and the protection of patient safety. So what is ADR? ADR is a practice of resolving dispute through processes other than litigation. The method of ADR varies among countries and it can be formal or informal. ADR techniques are diverse, for example, negotiation, mediation, conciliation, or arbitration, but also includes complaints and grievance procedure, ombudsman procedure, dispute resolution board procedures, expert intervention, and pre-trial screening. Common techniques used to resolve issues in healthcare, particularly potential medical negligence cases, are negotiation and early apology, mediation, arbitration, and pre-trial screening. So we will discuss more on this. Negotiation and early apology is the most informal form of ADR. It is simply a meeting between two parties to discuss the conflict and seek to achieve some type of resolution. These exchanges can be part of a program or facilitated by legislation designed to facilitate apology. Legislation such as apology law provides safe haven for parties to fully disclose matters without fearing that it could be misused as a proof for negligence. Mediation is regulated under Mediation Act 2012 and it is defined as a voluntary process in which mediator facilitates communication and negotiation between parties to assist them in reaching an agreement regarding a dispute. It is said to be the most reliable and effective method in resolving medical negligence cases, and it is slightly more formal than negotiation and can be done as a private or as a court annex mediation. Arbitration is the most formal form of ADR. This is where the parties are represented by lawyers to argue the cases before an arbiter or arbitration panel. At the conclusion, the arbiter issues a decision, and this decision is legally binding. A pre-trial screening is a way to screen out cases that are not based on merit and save costs to both parties. It is an informal screening before going to litigation by a neutral third party to assess the relative strength of each party's case. One reason it is particularly suited to the medical field is the high number of meritless cases in this field, and it can avoid wasting court time and cost. What are the ideal objectives to be pursued by regulation and policies in ADR? By establishing a regulatory framework for ADR, governments and legal systems aim to achieve the following objectives. Regulation aims to make ADR mechanism more accessible to parties who seek an alternative to litigation. This involves ensuring the ADR services are available at reasonable cost and are easily understood by laypersons. Efficiency is the core objective of ADR regulation. It aims to offer a quicker resolution to disputes compared to the often lengthy court processes. Efficiency saves time and reduces the financial burden on the parties involved and the legal system. ADR offers flexibility that court litigation cannot. Regulatory frameworks aim to preserve and enhance this flexibility by allowing the parties to tailor the ADR processes to their specific needs, including the decision maker's choice and control over the procedural rules. Regulating ADR helps maintain high standards of practice among mediators, arbitrators, and other ADR practitioners. This includes ensuring proper training, ethical guidelines adherence, and establishing accountability and oversight mechanisms. Effective regulation provides mechanisms for the enforcement of ADR outcomes, such as arbitration awards. This is crucial for the credibility and reliability of the ADR processes. Regulation often includes measures to promote awareness and understanding of ADR processes among the public and within specific sectors, encouraging its use as the first resort before considering litigation. So what is the current law, regulation and policies governing ADR in Malaysia? Currently, Malaysia do not have apology law. There are no structured program, policies or legislation to facilitate negotiation and early apology. In other countries, there are structured programs such as disclosure program and also apology law in place. In the United States, University of Michigan had enacted the program in 2002. It focuses on early patient-centered apology and explanation when adverse event arises. Despite no legislative protection, studies have shown that disclosure program reduces numbers of claims and the amount paid during settlement. As apology is only protective when healthcare provider gives an early disclosure, these two elements goes in tandem. These are the core principles of disclosure program. Prompt disclosure of the adverse event and expressing regrets and offering apologies. Having peer review for root cause analysis to find and improve shortcomings and prevent recurrence of event. Organizing a face-to-face meeting with patients and their legal representative to explore the adverse event, address the patient concern and discuss compensation options. Promote and cultivate a transparency culture where staff are encouraged to report errors without the fear of reprisal or backlash. Also, disclosure program is good. Healthcare providers still fear that the apology will be used against them as admission of negligence. Therefore, some jurisdictions confer additional protection to healthcare providers by enacting the apology law. It is an effort to protect the healthcare provider apologies from legal liability. New South Wales in Australia is the first jurisdiction in the common law world to enact legislation for the protection of full apology through an amendment to the Civil Liability Act 2002. In Part 10, Section 68, it defined apology as an expression of sympathy or regret, or of a general sense of benevolence or compassion in connection with any matters, whether or not the apology admits or implies an admission of fault in connection with the matters. Section 69.1 explains the effect of making such apology, that it does not constitute an expression or implied admission of fault or liability by the person in connection with that matter, and it is not relevant to the determination of fault or liability in connection with that matter. In Section 69.2, it states that evidence of an apology made by or on behalf of a person in connection with any matters alleged to have been caused by the fault of the person is not admissible in any civil proceedings as evidence of the fault or liability of the person in connection with that matters. Thus, it can be seen that under this provision, New South Wales offers full legal protection for medical apologies made by the medical practitioners. The working of full apology law requires three main elements that concern the position and consequence of such apology. They are the declaratory element, relevance element, and procedural element. For instance, in the Civil Liability Act 2002, Section 69.1a declares that apology is not an admission of fault or liability. This refers to the first element, which is the declaratory element. Secondly, in determining a fault or liability on the part of the defendant, Section 69.1b excludes apology from being taken into account as a relevant fact in determining fault. This provision is concerned with the relevance element. Thirdly, with regards to the procedural element, from the law of evidence perspective, apology made is inadmissible as evidence of fault and therefore cannot be used in court against the person who gave it, as stated in the Section 69.2. For regulation of mediation in Malaysia, the Mediation Act 2012 was introduced by the Parliament and came into force on August 1, 2012, with the aim of promoting and encouraging mediation as a method of ADR and to facilitate the settlement disputes in fair, speedy and cost-effective manner. However, there are no specific provision in the Act for medical negligence cases. Mainly, this Act is informal or for private mediation. What about court annex mediation or other formal mediation? Is there any statutory provision? For now, there are none. The Act does not oblige parties to mediate before litigation or arbitration. Also, parties may choose to mediate simultaneously with any civil court action or arbitration. There are some situations which this Act does not apply to, such as mediation conducted by court and mediation conducted by legal aid department, and matters that have been listed out in the Act, such as proceeding involving the Federal Constitution provision, remedy of temporary or permanent injunction, or any criminal matters. For court annex mediation, there are no primary statutory provision which expressly provide for litigating parties to resolve their dispute through this, or for courts to resolve dispute by mediation as an ADR mechanism. However, they rely on these two sources, which are Order 34 Rule 2 and Practice Direction Number 2. Order 34 relates to the pre-trial case management, which states that during a pre-trial case management meeting, the court has the authority to address various matters such as exploring the potential settlement of issues, requesting relevant information from the parties, and issuing orders and direction to ensure a fair, prompt, and cost-effective resolution of the case. This may include considering mediation as outlined in the current practice guidelines. In the practice direction, all judges of the High Court and its Deputy Registrar and all judges of the Session Court and Magistrate and their registrars may give such direction that the parties facilitate the settlement of a matter before the court by the way of mediation. They did not specify the subject matters as long as it is a civil matter related.
What about the law governing arbitration in Malaysia? In Malaysia, arbitration is governed by the Arbitration Act 2005, which is based on the UN CITRA model law. The Arbitration Act 2005 applied to both domestic and international arbitrations conducted in Malaysia, and the AIAC, formerly known as KLRCA, is a major arbitration institution that facilitates domestic and international arbitration. One of the purposes of this act is to encourage use of arbitration as an agreed method of resolving commercial and other disputes. As for pre-trial screening, do we have a law or policy for this type of alternative dispute resolution? MOH has a guideline on management of medical legal litigation. This guideline was realised back in 2017 and it serves as reference for all MOH personnel involved in the management of medical legal litigation by providing a workflow and the relevant involvement of the stakeholder. It details management of letter of demand, originating summon and notice of application, writ and third-party notice. What is a letter of demand? A letter of demand is a written communication from one party to another demanding a particular action. It is usually issued by the complainant or plaintiff legal representative demanding relevant documents, information or compensation. This is the workflow of management of letter of demand. So it starts with when healthcare facilities receive a complaint. This complaint will be analysed for any allegation of negligence or request for compensation. If there is allegation of negligence, this complaint will be managed as a medical legal complaint. An internal inquiry will be set up within 30 working days from the demand letter. An inquiry will determine whether the complaint is valid or not, or is there any shortfall in the management. The chairman of the inquiry will inform the complainant regarding the conclusion. If they are satisfied, then the case will be closed. But if they're not, the chairman will explore from the complainant their request and their expectation, including if they wanted to proceed with litigation. But if the claim only requesting for compensation, then the claim will proceed with ex gratia workflow. Ex gratia is a form of non-compensation scheme. The term derived from Latin, which means favour where no legal obligation exists. The objective of ex gratia payment are to offer alternative resolution of medical legal claims against MOH healthcare facilities and healthcare providers, and it also to reduce number of litigation against MOH healthcare facilities. MOH guideline in dealing with potential medical legal complaint do have some element of pre-trial screening in which it will sift through meritless complaint, but there is no direct contact between the complainant and the healthcare provider to resolve the issue at hospital or healthcare facility levels. There is also no step or mechanism to reduce the chance to proceed with writ or other legal summons. But let's have a look at our neighbouring country, Singapore. They actually do have a protocol to deal with potential medical legal complaint called Pre-Action Protocol. Pre-Action Protocol in Singapore was introduced by Singaporean Subordinate Courts Practice Direction 3 of 2006, and the ultimate aim is to facilitate early settlement of meritorious claims and discourage frivolous claims. So under this protocol, the patient will have opportunity to seek explanation or discuss their cases with the doctors and hospital without having to file writ to get their attention. So the process will start from the time the potential claimant contemplates filing a medical negligence claim in court. The claimant will request medical report from doctor and hospital. The claimant will write letter of request for discussion to which the hospital or doctor must respond within 14 days, proposing meeting which must be held within 2 months from the date of the letter. If the discussion failed to produce a resolution, claimant must give 10 clear days notice by letter to the potential defendant of his intention to proceed with writ. Claimant also must provide names of all parties he is contemplating in suing. So parties who do not abide by protocol may have to bear the cost of damages resulting from a subsequent court action. Why ADR need regulatory and policy reform? ADR needs to be prioritized as an appropriate dispute resolution strategy instead of alternative dispute resolution. And this strategy also should be a hybrid with tort system. We need reform because we lack definition of what actually constitutes ADR, and we lack the outlines of a well-designed ADR. For example, ADR that can encourage early settlement and provide clear pathway or channel to access. We also lack specific regulation or policies for resolving potential medical legal cases. We need this because medical legal cases are unique and complex in itself. We also have Mediation Act. However, this act does not emphasize regulation of practice of mediators and actually allows simultaneous dispute resolution method. But this will defeat the purpose of ADR. Why we think ADR require top priority for reformation? Because there's a lot of problem associated with litigation. So tort system adversarial in nature. They can offer money, compensation, but cannot address other needs such as explanation, apology, systemic improvement for patient safety, not to mention the burden of the litigation cost. Malaysian government spends 139 million on 206 litigation cases in the span of 10 years. And this burden of litigation costs will directly impact malpractice insurance costs, which ultimately increase insurance premium rate and increase the cost of medical fees for patients. Because of the affordability of litigation, this may prevent justice seeking by some population group who cannot afford litigation. It is also time consuming, there's statutory limits to it. It encourages defensive medicine, avoidance of high-risk specialty and cases by healthcare providers, and it also inhibits efforts to improve patient safety when healthcare providers are too concerned with potential litigation. What regulatory or policies will you propose to improve the delivery of healthcare service pertinent to ADR? We would propose a comprehensive legislation, regulation or policy that define ADR specific in resolving medical legal dispute with the aim to protect the interests of both patient and healthcare providers, sets forth the key principle of well-designed ADR program, and provide regulatory framework for structured disclosure program with mediation as the key ADR technique. So why mediation and not other forms of ADR? This is because mediation boasts a higher success rate in avoiding litigation compared to other ADR techniques. So how exactly can we achieve these objectives? Firstly, we can establish an in-hospital mechanism or an in-facilities mechanism that encourage early settlement. For example, having a structured early disclosure and apology program. Secondly, we can introduce apology law. Although in order to have a successful early disclosure program, it's not necessarily you need apology law. However, as part of a comprehensive legislation, introduction of apology law can certainly provide safe haven and protect healthcare providers and even encourage early disclosures and apologies. If we introduce apology law, it should be a full apology law and incorporate declaratory element, relevance element and procedural element as per Australian Civil Liability Act 2002, which was explained earlier during the presentation. And make this apology as a mandatory part of open disclosure. Why? Because apology is key element in open disclosure. What are the advantages of apology? It is effective in diffusing anger at initial stage, increasing communication, and reduce motivation to litigate. Apology initiate healing process, encourage settlement discussion, promote transparency and patient safety culture. It also protects from apology from being used as admission of negligence and be used as evidence in court. However, prior to implementation of this law, we should have a feasibility and viability study to see if what kind of apology regulation that suits a local legal landscape. Thirdly, we should improve the pre-existing Mediation Act 2012. How do we improve? By regulating the practice of mediator by standardization of competency requirement through accreditation system and not allowing multiple simultaneous dispute resolution method because this will defeat the purpose of ADR. We should also have a policy or regulation that offer compulsory mediation process before parties register the case at the court, where all the relevant parties, the victims, the medical practitioner, the healthcare insurance agent, representative of the Ministry of Finance, and an expert of medical negligence to assist in negotiating the quantum for the case with legal rights of the parties impact, in which the process may be handled by the centre such as AIAC. Last but not least, we would suggest that the MOH Medical Legal Guideline on the Management of Medical Legal Litigation to be revised to be more of a pre-trial screening protocol with preservation of ex gratia compensation scheme. And this should be integrated with an in-hospital mechanism such as the early disclosure and apology program. So that in this way, when the initial complaint goes through, it goes through one channel that are streamlined so that all the complaints can be systematically addressed.
And the next topic that we are going to talk about is the regulation of medical research and the protection of patient safety. We need regulation for medical research in order to protect patients from harm. And number two, to ensure the validity of research findings. Medical research, by its nature, definitely involves some risk to the participants. So therefore, regulation should be in place to help to ensure that the research is conducted ethically. And this definitely includes requiring the informed consent from the patient and participant to avoid any exploitation, having qualified researchers to oversee the studies, and we also need to protect privacy, safekeeping data, and having a plan in place to monitor or to respond to any adverse event that may arise from the research. Ethical values is also important to protect patients from harm. So, for example, respect for autonomy. This principle will ensure that the participants participate voluntarily and with full understanding, and informed consent is the key aspect of this. Patients also will receive clear explanation about the research, potential risk, benefits, and have the right to withdraw at any moment that they want to withdraw. Beneficence. Research should aim to benefit participants or future potential patients. Therefore, all the research should have potential research benefit that outweigh the potential risk for the participant. Researchers are responsible to minimize the risk and to ensure the well-being of the participant throughout the study. And non-maleficence. This is a core principle in ethics to emphasize on minimizing the risk of damage to the participants. Therefore, researchers should carefully assess the potential risks and take some steps to mitigate them. Rigorous review of the process to ensure research proposals are thoroughly evaluated before getting approval. And lastly, justice. Research participation should be fair and equitable. Therefore, vulnerable population should not be unfairly targeted or pressured to participate. The benefits and burdens of research must be distributed fairly across the different demographics. To ensure the validity of research findings, number one, quality of research needed to adhere to SOP and specific protocols. It has to be unbiased, and it also needs to have an ethical methodology which is also reviewed by an expert so that the data can be trustworthy and reliable. Other than that, regulation should be in place so that the findings can be trusted with ethical value in it. Therefore, this can ensure data accuracy, safety adherence, and as well as review by independent experts, and therefore it has created more transparency and people are more willing to participate. Here are the examples of law, regulations, and guidelines that oversee medical research in Malaysia. I will go into the detail of each one of them shortly. Control of Drugs and Cosmetic Regulations 1984, or we call it CDCR, mandates regulation of any drug used in the clinical trial. Therefore, this can ensure that the drugs has undergone some level of safety evaluation before being administered to the research participants. Number two, they have manufacture and quality control in place. So this regulation set the standards for manufacturing drugs that is used in research, and it helps to minimize the risk of contamination or inconsistency in the medication that was being tested. Number 3, which is the label requirements. Specific labeling is required to ensure research participants and healthcare providers have access to the clear information about the drug that is being tested, this will include the potential side effects, the dosage instruction as well. Number 4, monitoring and reporting. The CDCR may require the monitoring of participants for the drug adverse events, negative side effects such as, and during the clinical trials. This allows for early detection and intervention, if necessary, during the trial period. The Medical Act 1971 and its amendments. So this Medical Act plays a supportive role in protecting patients in medical research by ensuring the qualified and ethical medical practitioners are involved in the process. So this Medical Act is actually formed the foundation for regulating the medical profession in Malaysia, and it indirectly governs the medical research by setting the standard of medical practitioners who are involved in the research. So this act ensures only the qualified and registered medical practitioner can participate in research. Therefore, it can ensure a certain level of competence and knowledge when dealing with the research participant and their well-being. So, the professional conduct and ethics. The Act also outlines the professional conduct expectation for medical practitioners, and this includes the ethical consideration when dealing with participants, which can extend to the research settings. So, therefore, by adhering to this guideline, medical professionals involved in the research are obligated to always prioritize patient safety and well-being. They also have a framework for disciplinary action against those medical practitioners who violate ethical and unprofessional standards. This can serve as a deterrent against misconduct during research that could put the patient at risk. The Act ensures only qualified and registered medical practitioners to participate in the research. This will help to ensure a certain level of competence and knowledge when dealing with the research and the research participant and their well-being. Poison Act 1952 for research involving controlled substances. This act focuses on substances. While it doesn't directly govern medical research, it can impact research involving certain materials under the controlled substances. So this act involves restricting the import, possession, manufacturing, storage, and the use of poisons. Therefore, this could include some substances that are being used for the medical research. Therefore, researchers will likely need to have a license or exemption if they were to handle these substances. The Act mandates specific packaging, labeling, storage protocols for poison substances, and therefore ensuring the researchers to follow a safe handling procedures to protect themselves and also participants. Selling and supplying poisons to anyone under 18 is prohibited, except for medical treatment purposes. This might be relevant if the research involves young participants. Traditional and Complementary Medicine Act 2016 for research on traditional remedies. Research project investigates the effectiveness and the safety of traditional medicine product. The TCM Council might be involved in providing guidance and approval related to the specific products that was being studied. The Act ensures the TCM practitioners who are qualified and registered. This will be very helpful to identify the qualified practitioner that will participate in the research involving these practices. The Malaysian Good Clinical Practice Guideline is issued by Malaysian Ministry of Health. This guideline is like a rule book to run clinical trials fairly and safely. GCP ensures that the patient understands the risk and benefit before joining a trial through informed consent. This also emphasizes the well-being by requiring proper care and monitoring throughout the study. GCP set the standard for recording and reporting the data accurately. This helps to ensure the research results trustworthy and can be used to develop safe and overall effective treatments. GCP guidelines in Malaysia promote ethical research that protects patients and produces reliable data for medical advancement. The bodies governing researchers. Number 1, the NMRR or National Medical Research Registry. This is the main regulatory body for health research, including research on conventional and complementary medicine. Number 2, the MOH, Ministry of Health. This is the central authority for healthcare in Malaysia. They oversee several departments involved in medical research regulation. They also provide the overall guidance policies for medical research. Under the MOH, we have the NCCR Committee, which is National Committee for Clinical Research. They provide guidance and recommendation for improving the quality of clinical research in Malaysia. Number 3, the NPRA, National Pharmaceutical Regulatory Agency. This agency also falls under the MOH and is responsible for issuing licenses for clinical trials by ensuring the quality, safety and efficacy of the drug used in the research. We also have Research Ethics Committees, REC or IRB. These committees is established by individual institutions which are conducting medical research. They review research proposals to ensure that they are ethical and meet the safety standards before it can be proceeded. There are a total of 13 recognized research ethics committees in Malaysia. Each are responsible for the review of research proposals involving human participants conducted in their respective institution. And lastly, we have the MMC Council, which is Malaysia Medical Council. This body registered the medical practitioner and ensure that they maintain the acceptable standard of practice and extend to overseeing the ethical conduct of research by the medical professional under the registration. The various regulations and guidelines might not be perfectly integrated. This can lead to potential gaps and overlaps that can create some confusion. Also, some loopholes that can compromise patient safety. There also has been some concern in regards to enforcement of the existing regulation. Number 1, limited scope of existing regulation. For example, the Control of Drug and Cosmetic Regulation 1984 only regulates primarily the research involving medication. However, what about other research such as gene therapy or medical devices? These topics might have less regulation which are specific catered to them. Number 2, the other example is that the Medical Act 1971 only indirectly protects patients by setting standards for medical professionals. However, it doesn't directly address the research protocols or ethical consideration. Enforcement challenges. There has been some concerns about the effectiveness of enforcing the existing regulation. The resource limitation or lack of robust oversight mechanisms can create problems and vulnerabilities in this area. Addressing the ethical dilemmas. Due to the rapid advancement in medical research, there might pose some new ethical challenges that the current guidelines haven't been fully developed and haven't been able to address. Therefore, framework might need to adjust to be able to adapt and to address the emerging new issues. There might be lack of transparency in research approval process in how complaints are handled. This can erode public trust in the system and potentially discourage participation in research. And lastly, there might be some inadequacy for international collaboration. Malaysia regulation might not be fully aligned with the international standards, making collaboration with foreign researchers and doing collaboration with them more complex. Therefore, all in all, reform is needed due to these multiple lackings in our current regulation and laws. By addressing the potential shortcoming, Malaysia can actually work towards a more robust and effective system to govern medical research to ensure patient safety, fostering ethical conduct, and promoting public trust in research endeavors.